they really don't have the authority to take much action over a charter school. But they still oversee, they determine whether a charter stays or goes. And then now we're going to go over to what is special education? So, what is special education? We're going to start with the legal authority, your nuts and bolts of how you assert rights for children. And that is, the main one is the IDEIA, which we also often call IDEA and leave out the I, but that is the Individuals with Disabilities Education Improvement Act. And then there's the DCMR, there's local regulations. We have some newer laws that we also can use to assert rights, and that is, and you can see them listed here. I think the newest one is the Student Fair Access to School Amendment Act, and that has to deal with discipline. Then there's OSSI, Special Education Student Hearing Office Due Process Hearing Standard Operating Procedures Manual, also known as the SOP. And then there are also policies promulgated by OSSI and DCPS. So there's the DCPS, charter schools have policies and procedures that may not necessarily fall under one of the federal regs or DC regulations. IDEA, it covers children ages 0 to 22. It's an act that basically is the thing that talks about free and appropriate public education, a FAPE. It's a federal statute that is meant to ensure that all children with disabilities receive a free and appropriate public education in the least restrictive environment. That is what it's all about when it comes to special education. Is the kid receiving a FAPE? Yes or no? If they're not, bad. If they are, great. And then there's Part C, and that's for children ages 0 to 2, so the little kiddies. And then Part B, which is where the majority of our cases fall, which covers ages 3 to 21. Special education is specially designed instruction. Those are key terms, specially designed instruction provided at no cost to the parent that meets the unique needs of a child with a disability. It can include travel training, vocational training, specialized academic instruction, related services, accommodations, and modifications. Some of the related services: speech and language therapy, occupational therapy, physical therapy, counseling services, transportation services, medical services, parent counseling and training, which is one you don't see very often, but is something that, if was necessary, you could advocate for. All of these you'll hear, people will just say OT, PT, and speech, and behavior services. So these are different related services that can be added to an IEP. Some of the accommodations and modifications, they can vary. They can be, if you can think of it and you can, if it's something that a child needs, you can try to advocate for it. A dedicated aid, that's a big one that we often have to advocate or fight for. Use of iPad or technologies, assistive technologies. If a child needs some sort of assistive technology to speak or use for speech to talk, then that's something they can ask for. Special seating, if you want the child to sit in the front of the classroom, certain type of furniture, time for testing at the best time of the day, just different things that you can add. And I will say that as far as creating an IEP or going to an IEP meeting, this is very key. Accommodations and modifications are at the back of an IEP, and so sometimes if you're in a meeting, you're going through everything, and this is some that can be an afterthought. So you want to make sure that you are looking at what kind of accommodations does the child have or does the child need. And then you can also have use of calculator and different types of directions. So, free and appropriate public education, a FAPE, special education and related services. It means they're provided at no charge to the parent under public supervision and direction. They meet the standards of the OSSI and designed to meet the individual needs of a child to ensure the child makes educational progress. And they have to be provided in conformity with the child's IEP. So the school can't say, we don't have enough money to provide FAPE. We know this kid needs a psychological evaluation, but we just can't afford to to pay for that. That is not an excuse. That's not your client's problem. That's not your problem. They are responsible for providing FAPE at no charge to the parent. And a child's education, part of FAPE is a child's educational progress cannot be trivial or de minimis. It must be appropriately ambitious in light of the child's unique circumstances. And that is the new standard under the Supreme Court case Andrew F. And if you want the site, we can definitely provide it to you. But it's Andrew F. It just came out, I think, March 2017. So a school can't just provide, yes. Sorry, back to the previous slide. Mm-hmm. Well, so you'll have usually it's the case manager, but I mean, it just depends on who. Oh, the question was who writes the IEP? Thank you, Jen. And so who can write the IEP? I mean, honestly, it can be the special education coordinator so they'll have an IEP team. You'll have a special education coordinator, and then you'll have a case manager that's basically the special ed teacher that's assigned to that kid. And so it's usually one of them that writes the IEP and drafts, like I guess puts it in draft form. And then when you have the meeting, then you discuss it. But the one that's usually like putting in the information. But then again, as far as related services, your speech language pathologist is going to write the speech goals, or your occupational therapist should be writing the OT goals. So it should be a combination of people inputting information depending on what the services are. But if it's just like specialized instruction, then that's the special ed teacher, the special ed coordinator. So going on to another key term is child find. DC must ensure that all children with disabilities or suspected of having a disability and they are needed in special education services are identified, located, and evaluated. Child find is in the federal statute, and it just means that, let's say you have a kid that they don't have an IEP, they're not in special education services, but they're going to school and they're getting suspended on a regular basis. Schools they keep getting suspended. If they notice that, then they need to determine, hey, is there more going on here? Does this child have a suspected disability? Is there something that we're missing? This kid is being suspended. They're missing academic time. It's impacting their education. Is there something that's going on? And they should be saying, hey, this kid might need to be evaluated. So they're supposed to find them. Oh, this kid that's being suspended all the time, I think we need to identify them and then say, hey, does this kid need to be evaluated? It doesn't matter if they're homeless. It doesn't matter if they're in their school or if they're in the city, they should be found, identified, and evaluated to determine whether there is a disability there or not. So that's the definition of child find. Like I said, it applies regardless of the severity of the child's disability, and includes children who are not attending school, they're homeless, they're attending private schools, they're a ward of the district. And so they should be trying to determine if they suspect there is a disability. Now, they're not supposed to just evaluate any random child, but if they suspect that there is something going on there that might lead to a child needing more support, then they should be trying to identify and evaluate. IEP, Individualized Education Program. This is basically your blueprint for a child's education. It's a written statement for each child with a disability that is developed, reviewed, and revised in accordance with IDEA. The plan governs what a child in special education should be receiving. So once you determine this child is eligible for special education, and we will go through the steps in a little bit, but once you determine a child is eligible for special education, now the question is, how do we educate this child? That's what your IEP is. It should include in there what steps, what do we need? How are we going to have this child make progress? What does this child need? What's the individualized need for this child? An individualized education. So it's sculpted and tailored for this particular child, and it's appropriate based on the child's disabilities. That's what the plan should be. It should be current, and it should include all the things that the child needs in order to get their education. The IEP is the centerpiece of IDA's education delivery. If your IEP is not right, then the child's not, and they need an IEP. IEP is not appropriate, they're not getting an appropriate education. In other words, they're not getting a FAPE. The least restrictive environment, the LRE. So to the maximum extent appropriate, children with disabilities are educated with children who do not have disabilities in a regular education classroom. Children with disabilities should attend their neighborhood school unless that school does not have the kind of program that can meet their needs. So what you'll often hear is like, is this school the LRE? Is another school the LRE? The LRE is how much can this child interact with children who do not have disabilities? Can they be in the classroom? Do they just need, reading support? They need just specialized instruction in reading, and they can go to lunch with children that do not have disabilities. They can interact otherwise. They just need minimal supports. Or do they need significant supports? Do they need to be in a special education day school where they don't interact with children that don't have disabilities at all? What's the least restrictive environment? What is to the maximum extent, where can they be? And this is really, LRE comes into place with placement, and we'll talk about placement in just a little bit. But LRE has to do with where should this child be? What's the best setting for this child? So steps to obtain special education. Oftentimes we have clients come in, or we have doctors that we talk to. How do I get an IEP? How do I get my kid into special ed? How do we get my patient into special ed? And there's really 7 easy steps that will get you into special education. And this is where we come in, because typically we are advocating along the way at any one of these 7 steps. So first step is referral. In order to be evaluated for special education, a child with a suspected disability must first be referred for evaluations. So they can be referred by a parent, employee of the school, adult child, employee of another state agency. So let's say parent says, I want my child to be evaluated. They're fidgety in class, and they are having trouble reading and having trouble with math, and they're always getting sent home. I think my child needs to be tested. So they refer to the school. How are referrals made? Referrals should be made in writing to the school system or the principal. So if a parent wants to make a referral, the first step is they should be writing to someone at the school. Referrals for children ages 0 to 3 should be made to OSSI, and for early intervention, and that's Strong Start, and that's separate from DCPS, but still it goes to the SEA. And then referrals for children ages 3 to 5 should be made to early stages. The school must then hold an MDT IEP meeting after the referral is made and before conducting evaluations. So sometimes a parent will refer, and then a year will go by and nothing will happen. They say, hey, we wanted testing. So the school must hold an IEP MDT meeting to discuss the referral. So at the meeting, what should happen is the school should gather, an MDT team, multidisciplinary team, MDT team, and they should review the current information and data about the child and anything related to, referral interventions. If further evaluations are needed, they should develop an evaluation plan that says the reasons for the referral and the evaluations to be conducted. And then they should explain to the parent what evaluations are to be conducted. So they should tell the parent, we're going to do a psychological evaluation. We're going to do a speech and language evaluation. We hear what you're saying. Maybe this child needs a functional behavior assessment to figure out what's the reason for the behavior. But they should be explaining what they're going to do. And then they should obtain consent from the parent at that time.
One question. So when you say that the school should, would you say these practices are generally understood throughout different schools in the district? Or is there kind of a best practices that they're aware of or maybe sometimes don't abide by? Or how I guess what I'm asking is, how would they know that they should be doing this?
By law, they're supposed to be doing it, so they should know.
They should have.
Yeah, yeah, I say should because they don't always,
Okay.
but by law, yes, they know that when this comes about, they should know this is what you're supposed to do.
Okay.
So if a school has no idea, that's a major problem, but they should know. Yes.
Okay.
Yes, in fact.
So is there like a time period associated with these steps? So they have to respond in a certain amount of days after they get notice that somebody needs help or something like that? How does that work?
So it should be for referral in the meeting. It should be pretty quick. Like once parent makes the request for a referral, if anything, the school might say, "Oh, well, we just need time to schedule the meeting, or we need time to gather information." But they should be doing from referral to meeting to determine whether evaluations need to happen. That should be pretty quick, like a week, 2 weeks. We don't give them much time, and I don't think there's anything in the law that says they have so many days to make the referral. But it should be within a reasonable time. Usually, when we get involved, it's like it's been months, So but it should be. It's a pretty, it shouldn't take that much out of them to set up a meeting and start discussing this. So the MDT team and the IEP team should include the parent, a special education teacher, an individual who can interpret evaluation results if there's an evaluation, other persons at the discretion of the parent, the child, representative of the LEA, which is usually a principal or something like that. So that's what your MDT IEP team should include. Sometimes you'll have a meeting to discuss evaluations, and it'll just be, or discuss the referral, and it'll just be like the parent and the principal, and it's not necessarily the appropriate people that need to be there to discuss it, and that's where sometimes there can be issues. So the LEA is responsible for conducting a comprehensive and individualized evaluation. Now, one thing I should say is, so once they decide, so let's say they say, hey, okay, this kid needs to be evaluated, but oftentimes I'll go back to when the referral is made. Sometimes what will happen is they review the information and the data about the child, and they say, you know what, the school says, we don't think that there should be any evaluations. We think this kid is fine. He doesn't need any evaluations. She doesn't need any evaluations. So we're not doing anything. And that is not what's supposed to happen. What's supposed to happen is if the parent says, I want this child to be evaluated, then the child should be evaluated. The school can't say, no evaluations. We don't think that they're necessary, so we're not giving them. The law says either you give the evaluations or pretty much we're going to ask for an independent evaluation. But the school can't just cut the parent off and say, no, we don't think you need evaluations. The school also can't say, what evaluations do you want, parent? You said you want your kid to be evaluated. What kind of evaluations do you want to happen? You can't name them, then we can't do them, which is often what sometimes happens. And that's when you have to say, you should, first of all, as educators, they should know what evaluations need to be done. But also you can say in all areas of spectrum disability, if a kid has issues with ADHD and reading and academics, then they should know what evaluation to do. Yes.
The school would pay for the independent evaluation?
Yes, the school will pay for it. It's still free to the parent, and the school should be paying for it. So the LEA is responsible for conducting so let's say the school is like, yes, we'll definitely do it. Then the LEA is responsible for conducting a comprehensive and individualized evaluation to determine whether the child is a child with a disability and to determine the educational needs of the child. So the key here is comprehensive. If you have a child and there's this, and there's a suspicion that there may be a autism disability, and they do an evaluation and they don't test at all for autism, that's not comprehensive. So when you get an evaluation, you want to make sure that it tests all areas of suspected disability, not just, we just did it, because sometimes the school just like, well, just did an educational evaluation, kid's fine. And it's like, the kid, you didn't test for half the things that we were concerned about. So you want to make sure it's comprehensive. DC allows 60 days to complete the initial evaluations. Up until recently, it used to be 120 days DC had to do evaluations. Now it's 60. So it's just something to keep in mind that could be something that you have to remind the school of, that you don't have 120, you have 60 days. And that's not just to do the evaluation, that's to do the evaluation and hold the eligibility meeting as well. There's several types of evaluations that you can ask for, starting with the psychological. There's a couple different kinds. The thing about the psychological evaluation is some of these terms nowadays are used interchangeably. So you have psychoeducational evaluation, clinical psychological evaluation, and comprehensive psychological evaluation. A psychoed means there's going to be an academic component. Sometimes they'll say psychological with educational component. And then a clinical psychological, sometimes there's no education component to that. They'll just do like social emotional testing and cognitive testing. But I feel like more often than not, a clinical is also going to include the education testing as well. And then a comprehensive psychological evaluation. That's typically the way I ask for them, because it just makes it like, I feel like it makes it clear that I want a comprehensive, which means everything, including academic, social, and cognitive testing. Then there's neuropsychological evaluations, which are rare that schools will authorize those. It's rare that they do them, but it's conducted by a neuropsychologist for children who have an underlying neurological disorder. So typically, sometimes I feel like you see them, let's say, a kid has seizures often. It's used to like look at the deeper like neural logical functioning and processes of a child's brain, I guess. You don't necessarily, and I will say, you want to think about whether you need a neuropsych or not. You might want to ask for a psychological and then determine like whether you need more than that, or whether a psychologist will say this child makes recommendation for a neuropsychological evaluation, and then go from there. But sometimes you can sometimes get the same information from a psychological evaluation, depending on what you're looking for. So there's three main, yes.
Who makes the decision on which tests and who implements those tests?
Well, so if you're asking a school to do one, as far as decision, it should be a team decision. But if a parent is, I guess, if the parent is coming, and it kind of depends on how the decision, like what's the reason for it. That's one of the things. So if this child let's say, for example, I had a case where a kid had a alcohol poisoning and like passed out and was in the hospital. I can't remember what it was, but she had brain damage. And so she was already in special ed, and when she came back to school, she was forgetting things, and they couldn't figure out why. So instead of doing a psychological again, they did a neuropsych. So the decision was made by the team of like, we need something more than just a psychological. So it should be more of a team decision. It shouldn't, and everyone should kind of agree, okay, that's the one that needs to be done. But typically, if you're asking for evaluations, a school is just going to come out the box and say psychological. They're not going to go back and forth of like, hey, well, they're going to do a psychological. They know they need to do all the three areas, which is cognitive, social, emotional, and academic. That's just kind of standard. So
Does the school pick these for people to do the evaluation?
they can have someone on site. If they have a psychologist, a school psychologist, they can have them do it. A school psychologist, if they have a school psychologist that has a master's of psychology, then they won't do a clinical, but they will do a psychological evaluation that will give you like the identifications for like, oh, child should be classified under IDEA, these classifications. A clinical psychological will give you like the DSM diagnoses, and that's done by someone who has a doctorate of psychology. But they have someone, they can have someone do it on site, they can have a contractor do it. It just really depends.
The school pays for it.
Yeah, school pays for it. Yep. So there's three main areas: cognitive intelligence, social emotional, and academic testing. You want to make sure those three things are there when you get a psychological back. And like I said, there's a school psychologist and a clinical psychologist. School psychologists only need to have a master's and be licensed by OSCE. Clinical psychologists have a doctorate of psychology and they have state licensure to practice. School evaluations will give classifications from IDEIA, and IEEs, independent evaluations by clinical psychologists, will give DSM classifications. But sometimes, oftentimes, I feel like the clinical psychologist will also make a recommendation for an IDEA classification. So they may say, and also too, those are things that still can be considered. So if a DSM diagnosis is autism spectrum disorder, and a school can't say, "Oh, that's from the DSM. We don't know anything about it." No, that there's a correlation to the identifications under IDEA. So you can't just like ignore it and say, "Oh, we can't do anything with that." So there's a psychiatric evaluation, which rarely, I feel like that they're asked for. I mean, they're conducted by obviously a medical psychiatrist. They're permitted, but again, it should be in conjunction with a psychoeducational. And you may not need a psychiatric evaluation for the purposes of educational impact and educational performance. So there's other types of evaluations: speech and language evaluation, occupational therapy evaluation, physical therapy evaluation. I will say for occupational therapy evaluation, something to keep in mind is that OT evaluations can be done for, fine motor skills, but also for sensory differences. So let's say that, like I said, let's say you have a child and they have a diagnosis of autism, but the school does an evaluation, they do an OT evaluation, and they only test for fine motor skills. I'm like, yep, kid's fine. But the kid has a whole bunch of sensory needs, but they don't test for those. Then you won't see that. You'll think, oh, they just have, so you want to make sure with the OT, if you're looking for that, they test for sensory difficulties, if that is an issue. So if they're like, oh, the kid is, really struggles with sensitivity to sound, they should be testing as far as sensory differences as part of OT. And then physical therapy evaluation for gross motor skills. There's assistive technology evaluations, looks at whether any technology can assist the student's educational functioning. That can come into play for, like, say, a kid with that's nonverbal and needs other ways to communicate. Is there any assistive technology that can help that child? And there's tons of things. I had a child that was visually impaired, and she needed, we had an AT evaluation. There's also another one for visual, but to determine like what other technology could assist the student's functioning. Then there's a functional behavior assessment. And that is a series of observations to determine the root causes and triggers of a student's problematic behavior. So let's say this child is being suspended all the time, and the school, you keep having meetings, kids getting suspended, kids doing all these things, and the school is like, the teachers are like, we don't know why that little Susie is doing what she's doing. We have no idea why she's throwing chairs every day. That's an opening for a functional behavior assessment. You want to figure out, the school should be figuring out what's the cause of the behavior, what's the reason for the behavior, what happens before the behavior starts, how long does it take to end. These are things that should be looked at in a functional behavior assessment, because it's going to be hard for the school to put supports into place if they don't know why the behaviors are happening. So that's definitely an assessment to be considered if there's problematic behaviors at school, and they can use that to create a behavior intervention plan, which can go along with an IEP. So, group exercise time. A child you are working with has been diagnosed with ADHD by his primary care doctor. He has no services at school. Your client's main concerns are very fidgety and unable to sit still, unable to focus on work for more than a few minutes. Child is very impulsive, has trouble following directions, and mom is concerned that he may not even understand those directions. What evaluations do you ask for? Give you a couple of minutes. Okay, yes.
Okay, so taking a stab. So if we already know he has ADHD, perhaps that may have been diagnosed in the past by like a doctor or like a clinical psychologist. So could you start with a comprehensive psychological exam to kind of like explore it?
Yes, you could. Yes, definitely, that's correct. You could ask for a comprehensive psychological exam to see if there's something there that's impacting. Anything else? Yes.
I would ask for speech and language evaluation because he's having problems processing language.
Yes, exactly. Yes, you would ask for a speech and language evaluation because she says he's having trouble following directions, and it's not clear if he's even understanding what's. So there's a process. There could be a processing issue on him receiving that information. Yes.
Would you also ask for a functional behavior assessment to see if you can figure out what specifically, like when in the day, what are the things that are causing the disruptive behavior?
Yes, that is also correct. You'd ask for a functional behavior assessment to see if what's causing the behavior, what's triggering it, and to see so that you can figure out how to make it better. Yeah. Yeah. Anything else anyone thought about? Yes.
Isn't the purpose of the psychological examination to figure out the root cause? So I'm not sure how that differs from the functional behavior assessment.
That's a good question. I mean, they're different because the psychological evaluation, the assessments, the functional behavior assessment is pretty much all about like observations and now a psychological, there are observations as well, but it's a little more in depth. So you wouldn't just want to ask for, like a functional behavior assessment is to assist with what you've learned from the psychological. So if you're learning in the psychological, you're going to get the cognitive information, you're going to get the social emotional information. And then once you have that, if you have a psychological evaluation that says this kid has like kind of a low IQ, and then also you find out that, some background information about social history, you're just going to get so much more, but they should still take that information and then also do observations because functional behavior assessment really is about that behavior, whereas psychological is like about the whole child.
What are your thoughts about being able to get 2 bites of the apple? So if you ask for these 2 tests and wait to get a 3rd test, depending on what these 2 do, we have to start all over again in the process to get everybody to meet, to make a decision, et cetera, to get that second step done. Maybe it's better to try it all together, or when you try it the first time, say, and if we find this, we go to this.
If you suspect something early on, it's fine to ask for them all. The school might say, well, let's see. It depends on what it is. Like if you're saying, I think there might be, it just depends. I feel like if you're thinking like, oh, there might be speech issue there, you might as well ask for them all at the same time, like a speech psychological. It's fine to ask for them all. The school might say, well, we want to wait and see, but I would advocate to just do them, to ask for them all at the same time, because they're still going to get the time to do them, and you're going to have to come back and meet and review them. So it makes sense to review everything at once because it's all going to work together. So once step 3 is eligibility determination. So once all the evaluations are completed, the school must convene another MDT IEP meeting. And the meeting is to review the evaluations. The meeting must include someone who can interpret the evaluation data. Now, again, once the evaluations are completed, the school must convene a meeting. It doesn't have to, you want to just ask, once you send them evaluations or once they receive the evaluations from their team, it shouldn't take that long to meet. They might say, if it's an independent evaluation, we need time to review. Okay, that's fine, but it shouldn't take longer than 30 days to come to the table to meet. And if you're scheduling it, it should be pretty reasonable time that they're coming back to look at the evaluations and determine eligibility. There's nothing in the law that necessarily says you got to come back within a certain amount of days, but it should be a reasonable time because what are you waiting for at this point? If you have the information, you should be reviewing it. The MBT must determine if the child is a child with a disability and that disability impacts the child in the school setting such that they require specialized instruction. That "and" is key because if the child has a disability, but it's not impacting them, which is, then they may not need an IEP. And that can happen. There's children all over world, I'm sure, that go to school, they might have a disability. Doesn't mean they need an IEP, but it has to impact the child's school setting, and it has to impact their education, requiring specialized instruction and related services. Sometimes, as the attorney advocating, that's the part that you end up having to advocate for. Like, the child has a disability, and this child has a learning disability, and they're on the first grade level and the 10th grade, so it's impacting their education. So that's what you want to come to determine at the eligibility determination. When making a determination, they must review all the evaluations and relevant information. That includes information from the parent, anything from the assessments conducted in the classroom, observations of teachers and related services. Sometimes the school will have an eligibility meeting and they will not bring any classroom teachers. I had a case like that. They just kept refusing to bring classroom teachers to the eligibility determination. And so it was just the principal, the parent, and like, I don't even know who the other person was, but and we wanted to hear from the teachers, because we knew the teachers had information that would support, the eligibility determination. So you want to make sure that you ask, if you're having a meeting to talk about eligibility and the teachers are sitting there, you want to ask them, what do they see? Now, sometimes the teachers will just say, things are great. It depends. But you'll know if what they're saying is legit, or if it's just like, okay, they're not on our side. It just depends. But sometimes teachers will be very honest and say, he's never in his seat. He's only in his seat like 5 minutes out of the day. And that's the kind of information that you need and you should be considered when making an eligibility determination, along with evaluations and input from the parent. Yes.
I'm just curious, like, practically speaking, at that stage, do you find that the schools or the teachers or the administrations are truly adversarial and are having a strong position that it's not necessary, or is it just more lighting the fire under them to do the steps they're supposed to take?
No, it varies. I mean, it's not uncommon for them to be very adversarial.
So to dig in and how to position it,
Yeah.
not necessarily actually why.
Yes, and dig their heels in on that. I think one thing to keep in mind with special ed is, the schools, and sometimes there's a, I don't know if it's ego or there's a personal feeling there. Everyone's human, and so sometimes it's a combination of you're not going to get past us on this, and sometimes it's just we're all, there's one person. There could be like the principal that's like calling the shots and saying like, you better agree or else, so it varies.
And do you find, again, it's a huge generalization, but that the posture or the experience for the attorney in one of these is different if it's a charter school versus a CPS?
No, it's school by school. It's school by school and team by team. So there's some DCPS schools that see what the need is and take care of it. There's some that don't. Same with charter schools. You can go to a charter school that's under the same LEA and get one thing from a different and one from another. So yes.
At this eligibility determination meeting, who is the person that qualifies as being able to interpret the evaluation data?
So you want to have someone, depending on what the evaluation is. So if there's a psychological evaluation, a psychologist should be interpreting it. If you have a OT evaluation, you should have occupational therapy, occupational therapist interpreting that. And that does come up. You want to make sure that the person interpreting is qualified. I went to an IEP meeting once, and there was a social worker reviewing an occupational therapy evaluation. She was not qualified to review that. And if those types of things come up, you want to make sure that you say something about it. Like, wait a minute, who's reviewing this? Because they can sometimes, it doesn't happen that often, but it can. You just want to make sure that you're, aware of what's going on and who's doing what at these meetings. So disabilities under IDEA, you can see the list here. These are all the different disabilities under IDEA. Multiple disabilities is a combination of more than one disability. In DC, there's certain disabilities, I don't want to get too much into it, but there are certain disabilities that can go together as multiple disabilities and certain ones that cannot go together under the local, I don't know if it's a policy or a regulation, but so for example, you cannot in DC have a child that is classified as emotional disturbed and an intellectual disability. There's just certain disabilities that cannot go together, but I'd say that's another conversation for another time. These are the disabilities under IDEA. You want to make sure that you review these and don't just review these and review the definitions for these, which are in the regulations, and don't just allow the school to say this is what it is, because sometimes they're wrong and sometimes they use the wrong disability identification. So, for example, the case where the child had the alcohol poisoning, the school was like, well, she still should have a OHI, other health impairment, which I don't even see that. Oh, other health impairment because she had ADHD. And it's like, no, actually, she should honestly be identified as traumatic brain injury, because that was what was identified in her evaluation, not OHI. So you want to make sure that you review review what the disabilities are, and even that can be a point of advocacy, is what disability classification should it be. And you could have, school might say the child should have it, because I should say that could determine like what kind of education the kid gets. If the child has a learning disability, but they've identified the child as having an emotional disability, and their school placement is determined by that, they could be in a school or just with children with behavior, and they really have learning disability, and they're not going to get the services that they need. That's something that often happens. I had a due process hearing where that was the case, where it was like they were completely off. It was clear that the child had a learning disability, but they wanted to have the child have an emotional disability, which was inappropriate. So what if the parent disagrees? If the parent disagrees with the evaluation that was done or the evaluations that were done, they have a right to request an IEE, an educational evaluation, to be paid for by the LEA. Parents need to express their disagreement with the LEA's evaluation. The parent must say that they disagree, that's key, that they disagree with it, or they can disagree with the LEA's decision not to evaluate or not to comprehensively evaluate. And the LEA can request more information, but the parent doesn't have to give the information as a practical matter. It's a practical matter. It depends on the school. So some charter schools, for example, in DC, there's one particular attorney that works that is the attorney for several charter schools, and she always wants to know, why do you want to ask for one? And as a practical matter, there's usually a reason. We're not just asking just because. So it doesn't hurt to say like, oh, they're asking for it because it wasn't comprehensive. But you don't have to by law. They don't have to. The parent doesn't have to say why. They can just ask for an independent because they disagree with it. They can't say they just don't like it. They have to say they disagree with the evaluation. That is the key that opens the door to an IEE. After a request for an IE, the LEA has two choices. They have to fund or file. They have to fund the authorization for an IE without unnecessary delay, or they have to file a due process complaint against the parent to prove the appropriateness of their evaluation. This does happen from time to time, not very often, but the school might say, we're prepared to defend our evaluation. We think our evaluation is fine, so we're going to file a due process complaint. It happens not that often, but it does happen. Yes.
We've had some cases where the school has either failed to take any action after an IEP request, or has said, actually, we want to retest the kid ourselves, which, of course, the parent is not trusting that the second time will necessarily be as thorough. So and then the school district hasn't sued the parent. It's just said give us a chance to reevaluate it. So what are your thoughts in either of those, where the school district doesn't do one of those two things?
Yeah, it's unfortunate, but you'll have to file a due process complaint pretty much. That's really your only option. Otherwise, they're fine with it. Like, you have to file for failure to evaluate. I think that's what I've done, and that's pretty much only way you're going to get things moving, even though it's not technically what should happen. Yes.
Are there cases where the parent's interests diverge from the child's, like a parent who doesn't want to medicate for ADD or something like that? And in those cases, are we representing the child as our client or the parent? And I guess that may be something that's too specific. Right? Just does that come up?
Well, I will say in our cases, the parent is our client, so we don't represent the child. So I don't know. So there's just cases that we don't handle. If it's the parent, and if the child is like, only time that would come into play is if a child became an adult and they're like 18, and then we're talking about like who has, is there power of, attorney? Does the child retain the rights? And, so different things like that. But if it's a parent, our client is the parent. So if the parent wants it, then that's who we go by. So yes.
I filed a due process complaint with DCPS and a policy attorney represented DCPS. What happens in the Charter Act? With the charter schools?
As far as filing a due
Do
process.
they have counsel, or are you putting, and do they have their own due process, or do you go into the DC due process?
So the question is, filing a due process complaint against a charter school, what's the process and if it's different? So for charter schools, it's the same. Charter schools have attorneys, and you also will file a due process complaint at ODR. So it's still Office of Dispute Resolution. You still can use the same form. You file it at the same place. And what will happen is when you send that and we'll talk about due process and after lunch, but when you file a due process complaint, you're going to send it to the school anyway, to the principal. When you send it to them, you can send it to OSSI, and then when you get that notice back from Office of Dispute Resolution, it's going to have who the attorney is. So you don't have to worry about like finding out who that is before you file. So development of an IEP. So you got everything. You got your referral, evaluation. Everyone's on board. Everyone knows what the identification is going to be for the child. And now it's time to develop the IEP. The IEP is developed by the MDT IEP team and must include child's present level of performance, information on how the child's disability affects their involvement and progress in general education setting. They should have annual goals and objectives, and levels and types of special education services and program modifications. I would, the explanation of the extent in which the child will not participate with non-disabled children, and any accommodations required in the classroom and for standardized testing. One thing I would add on this is the child's present levels of performance. You also want to be looking at, when we look at the IEP, we'll look at what's on there, but you also want to be looking at, like, there's a section on an IEP under the child's present levels of performance. Under that, there's a section that has like baselines. So where is the child starting? And you want to make sure that the school is acknowledging that and accurately capturing where the child is so that you can measure, so that it can be measurable where they're going. So that's something also that's under the present levels of performance, but the baseline is also important. Other important IEP components: transportation, extended school year service, and then behavior intervention plans done after a functional behavior assessment. And a transition plan required for children ages 16 and over. So a transition plan should have age-appropriate goals relating to training, education, employment, and independent living skills. And as you can see, it is part of the regs, so it is something that should be a part of a child's IEP once they get 16 or older. Next step, placement. So once you develop an IEP, then the next conversation should be about placement. And that can be at the same meeting that you talk about the IEP and develop the IEP, or it can be a separate meeting. Typically, if things are going to get heated or adversarial, the placement decision the team might say, we're going to come back to talk about placement because they know it's going to be, there's going to be a back and forth. Otherwise, it could just be separated. It can be folded into the IEP. Placement is based on the individual needs of the child and that must consider the IEP. And like I said earlier, LRE. So LRE requirements. So they should be looking at, is this the most appropriate school? We developed this IEP. It's a great IEP. Can it be implemented here or should it be somewhere else or should something change? Placement is made by a group of, yes.
How long can a student stay in a public school? It's not, is it 18 that you're supposed to graduate, or are you allowed to stay until you're 21?
You're allowed to stay until you're 22, I believe, and I could be, but it's not 18. You have to, and that depends actually on what the needs are. So, and there's on DC, there's a box that says at the back of the IEP, it'll say like, is this 22 or is this 18? And so you want to make sure that and some kids, and I will say, I mean, that's another whole conversation, but graduation and things like that is a conversation that should be had with the client, because our clients are very sensitive about what it means a lot to them about what kind of, are you graduating with a diploma, certificate, when those things are very important. But yes, so it does go above 18. It can go above 18. Yes.
You mentioned that the IEP and the placement could conceivably be done at the same meeting, but those two meetings are separate from the evaluation meeting, or can they also be part of the same?
They can all be in one, but it's a long, long meeting. So typically they don't do, it depends. If you have one evaluation, so you're just doing a psychological evaluation and they've done it, the school's prepared to talk about IEP and eligibility, it can all be done in one. But usually they will say, we'll come back and we'll determine, because by law, they have time to come back to create an IEP. So the placement should be made by the parent, other persons knowledgeable about the child. It should be determined annually, so that should be looked at once a year at least, and it must be as close as possible to the child's home. Yes.
Are there timing requirements in statute or something? I mean, when you have to have the evaluation done and when you have to have your meeting, are there like time requirements? Like with the school, like just delay.
Well, you have to do the evaluation. Once the evaluation is determined, like that you've determined, yes, we're going to evaluate, they have 60 days to do that and then determine eligibility. Then they have 30 days to develop an IEP so that's in the law, that they have 30 days to develop the IEP after eligibility is determined.
And then what about placement?
Placement is technically it's part of the IEP, because where a child, that's part of the IEP, so they don't have another 30 days to determine placement. That's part of the IEP, yeah. Mm-hmm. But they might say, we'll come back next week to talk about placement. But placement, like I said, it's made by a group of people. You want to make sure the parent is there. Parent's not there, that is the problem. That is a denial of faith. The parent should be there to determine placement. Continuum of placement, instruction. There's different types of placements. Instruction in a general ed class, so inclusion. The kids in class with children without disabilities, and then they might have a teacher come in. Instruction in special classes. They get what we call pull out. So you get the special ed teacher comes and gets the child and takes them and works with them one-on-one or in a small group. And it can range from 1 to 2 classes to the bulk of the child's school day. Special education schools, educational placement, where a child spends all of their day in special education setting with special education peers, and they have no contact with regular education peers. This can be in a public school or a non-public school. The difference is, for a public school, they call it a self-contained classroom, and that's different than a special education day school. There's home instruction. And then instruction in hospitals and institutions. Residential programs are for kids unable to function in the community. Children with disabilities in residential programs must be able to access their specialized instruction. As far as hospital instruction or institution, if you have a child that has an IEP and they're in the hospital or they're in juvenile detention, they should still be getting their services. I think the only place you cannot, if you have an IEP, you can't get services is if prison. But jail, juvenile detention, hospitals, residential facilities, you should still be getting it. So IEP review. Step 6, we're almost to the end for determining eligibility. For getting into special education. So IEPs must be reviewed and revised as necessary, but at least once a year. A parent or school can request an IEP meeting at any time if there is concern about the provision of FAPE to the child. For example, child's regressing in academics. They've begun to act out, or they've made really great progress and the goals need to be adjusted. They need to have a less restrictive environment than what they're in now. So they can request a meeting at any time. A school can't say, or a special education coordinator can't say, oh, we already reviewed it this year. You'll have to wait if you're all your concerns till next year. No, a parent can call a meeting at any time if there's a concern about the provision of FAPE. So we're going to practice reading an IEP. Turn to the IEP in your handouts. I have to look at this. I think it's up at 6. Oh, 6. Yes. Thanks. So looking at this IEP, what do you see as the eligibility classification? Yes, emotional disturbance. That's correct. And from the IEP, what type of meeting is it? Yes, annual review meeting. Actually, I should put that there. So you guys see where the where it's the type of meeting down. Yep. What's the date of the meeting? Yes, October 29th, 2015. That is correct. And what services does the student get? Yes, speech. Anything else? I'll give you a hint. It's towards the end of the IEP, and it's on the screens.
Dedicated aid.
No. Where do you see dead? Oops, sorry. Yep, you see there's a no. They have a check no. All the services are above that. So, services are above that, like the specialized instruction. You guys see what that's on page 14, right? So this is where you're going to find, in DC, this is where you're going to find the services. Specialized instruction. See the setting, outside general education, beginning date, ending date, that's the IEP date. Time and frequency, they're getting 25 hours per week. And then under that, you'll see related services. You'll see occupational therapy, speech, behavior support services, time. So sometimes when we go to IEP meetings, the first thing we do, we get an IEP, we go right to the back to see what the services are looking like if we're concerned. Sometimes, I will say, sometimes schools, if they know they're going to do something that is unexpected, they'll hold this page. And you won't get this page until like the end. Yes, it's kind of silly, but that has happened. Like, where's the services page? And then you see it and it's like, oh my gosh, they changed everything. Okay, so we talked about the services. Is this inclusion or pull-out services? Pull out. Outside general ed. And then, you know where you can see that? Look at the setting. It's outside general education. And 25 hours per week. So this kid is spending all of their time outside general education. They do not have any, they're not in classes with general in a general ed setting. They are in a, well, I don't want to give away the answer, but what kind of school is it? Yes. They're in a special education day school. You can see that at the top it says District of Columbia IEP, right? But look at the school site. It's High Road Upper School of Prince George's County. Yep, it's a special education day school that where the child is. So, very good. So, reevaluation. A child who receives special education services must be reevaluated in all areas of suspected disability every 3 years unless all members of the team agree that it's not necessary. A school may not unilaterally make a decision not to evaluate. The team's decision not to evaluate should be documented. A child can be reevaluated more frequently at the request of the parent or the teacher. So it should happen. They should be reevaluated every 3 years unless all members of the team agree that it's not necessary. That includes the parent as part of the team. So if the school doesn't reevaluate it for like 10 years, and they're like, we all agreed, it can't just be the school. They may not unilaterally make the decision. If the parent is not on board with that, then it has to be done every 3 years. School must also reevaluate it as conditions warrant. Procedure requirements for the provision of FAPE. The LEA must provide the parents a copy of the procedural safeguards, opportunity to review child's records, opportunity to meaningfully participate in IEP meetings, and the opportunity to obtain an independent educational evaluation. And I'm just going to skip here because I'm behind on time. Prior written notice. An IEP, once you have an IEP, once you're in, the child has been determined eligible for special education, you should keep in mind a prior written notice, the description of the agent's action proposed or refused by the agency. So you can ask for, if the school says we're going to evaluate, they should provide you what they call a prior written notice that shows all the things that they're going to do or the reasons why they didn't take action. So if you ask for placement in a non-public or a special education day school and they don't do it, they should describe why they took the action they took and what they proposed to do instead and why they made a decision. The prior written notice should give you the insight on why they did what they did. Schools don't often just voluntarily give those out, but you should be asking for them to make sure you have that documentation. So we'll skip on to that. Here's a copy of a prior written notice. This one is about evaluation. As you can see, it describes the actions, description of proposed refused action per parent's request. A comprehensive psychological evaluation is to determine eligibility for special education services. So that's just something you can take a look at. Troubleshooting denial of FAPE procedural issues. These are some of the procedural issues. I won't spend too much time on them, but as far as denial of FAPE, so timeline violations, IEP, notice to parents, timely evaluations, IEP implementation. So let's say IEP is supposed to expire tomorrow. IEP expires tomorrow, the date, expires tomorrow, but there's no meeting tomorrow. If the meeting is in a week, that's a procedure violation. They should have the IEP before it expires. But if they don't, they have it in like a week, then there's not a denial of FAPE. There's no harm there. But if the IEP expires tomorrow and they don't do that to next year, then now you have a procedural denial, but it's also leading probably to a substantive denial of FAPE because there's other things at issue. Substantive issues, meaningful progress, that might be something that's at play. IEP implementation, now you're into, like I said, if they haven't done anything for the IEP, or let's say they're not even implementing the IEP, that's a substantive violation. Appropriate educational placement, appropriate teachers and therapists. These are things that are substantive issues that may not be like you can just look at the law and say, hey, they didn't, 3 years passed and it's 3 years and 1 day. These are the substantive issues. Procedural violation is equals a denial of FAPE if it impedes the child's right to a FAPE. Like I said earlier, if it causes a harm or it impedes the parent's opportunity to participate in decision-making process regarding the provision of a FAPE to a child. Discipline, suspensions, and expulsions. Students with discipline, Students with disabilities have special protections in disciplinary matters. They can still be suspended, but depending on the number of days, schools must follow certain procedures. A student with a disability is always entitled to a FAPE and can never be excluded from receiving an education. So these protections cover children with disabilities who have not yet been found eligible for special education if the school system knew or should have known that the child is a child with a disability. So it comes back to that whole child fine thing. Like they're covered under that umbrella. If a child is being suspended, but they're in the evaluation process, they're also covered under that IDEA umbrella. The new discipline law. This is a new law that just came into play, which is the Student Fair Access to School Amendment Act of 2018. It sets limits on schools' use of suspensions, expulsions, and involuntary transfers. It's uniform school discipline that it applies to DCPS and public charter schools, out of school. So what are some of the things that it covers is out of school suspensions cannot exceed 5 days, 5 consecutive days for grades K through 5. It cannot exceed 10 consecutive days for grades 6 through 12, and a student cannot be suspended from school for more than 20 cumulative days in a school year unless the head of the LEA provides written justification. So before, a kid could get suspended for 45 days, 90 days. So these are some other key provisions, which you can take a look at. And then extra protections for students with disabilities. Excluding a child with disabilities from class for more than 10 days is a change in placement. Therefore, the school must hold a meeting to determine whether this behavior is a manifestation of the student's disability. This meeting must take place whether it has been 10 consecutive days or 10 days throughout one school year. So if you have a parent that's like, my kid was suspended 3 days at the beginning of the year, and now they're suspended another 5 days, you need to be asking, how many days has it been? So that you know whether it's time to have a manifestation meeting, determination meeting or not. If it's a manifestation and the result of the school's failure to provide appropriate services or implement the child's IEP, then the suspension cannot take place, which means the kid returns back to school. A manifestation determination, it's a meeting of the child's IEP team to determine if the behavior that led to the disciplinary action is substantially related to the child's disability. One thing under the new law is they have to consider all disabilities. They just can't consider just one. They have to consider all the child's suspected disabilities, not just the one that they see on the IEP, which is what it used to be. The team must convene within 10 school days to determine if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, not whether the child knew right from wrong. Sometimes schools will say they know what they were doing when they broke that window. That's not the standard. Or if the conduct in question was the direct result of the LEA's failure to implement the IEP. So the school has an IEP in place or not, they don't even have a social worker on or a psychologist on staff. Kids not getting behavior support services. So then they're not implementing it. And that's a problem. And DCPS also considers if the IEP was appropriate. And they also should review other information, evaluations, observations, current IEP information by the parent. If the team answers yes to any of the questions and the behavior is deemed to be a manifestation of the child's disability, and then the disciplinary action must be rescinded. So they must go back to school right away after that. It can't be like, well, come back in a week. No, there's no suspension, then they get to return back to school. There is an exception for incidents where the child has a dangerous weapon, drugs, or cause serious bodily injury. One thing I would say, serious bodily injury. If you look at the regulations, just keep in mind, serious bodily injury is not necessarily just pushing a teacher down. It's like putting someone in the hospital unconscious. It's under I think it's the Criminal Procedure Act. When they say serious bodily injury, it's not just like, schools will use that sometimes and say, oh, the kid, it's serious bodily injury because, the other student got pushed down on the ground. That's not enough for it to be serious bodily injury that warrants the exception. So here are some of the things that you need to do. If after the manifestation determination results, conduct an FBA, review a behavior intervention plan. And if the parent disagrees, You can do an expedited due process hearing is always available. And so there's due process rights that come after that. I'm going to skip here. Do we have time to do the hypo or no? Okay, we'll just do it together. We kind of already talked about it. Desiree is a 6th grader with an IEP that provides specialized instruction and counseling services. Her disability classification is OHI or other health impairment. After getting into a big fight with some other students, she is referred for a 30-day suspension. As you prepare for the meeting, your client tells you that Desiree loved her counselor at the beginning of the school year, but she quit and she's not sure who her counselor is now. What would you consider, what arguments would you raise at the MDR? What do you think a school would say? Right. Raise time of suspension. What about the fact that the counselor's not there? She says she's not getting counseling. She has counseling services on her IEP. Right. There's an implementation issue there. So maybe the IEP is not being implemented. What arguments do you think the school would raise? They might say that school might say the school counselor is not there, but the phys ed teacher is also doing counseling instead. Or the school might say she was in a big fight, she started it, it's her fault. We talked to her about this, and if she wouldn't have an attitude, this wouldn't have happened. We don't think she's entitled, she's supposed to have a 30-day suspension. They could say anything, pretty much.
They can't say anything to justify the 30 days, unless she brought a gun or something.
Yeah, they could say that it was a serious bodily injury. She got in a big fight with some students at school. One of the students had a bloody nose. Just serious bodily injury. So she deserves a 30-day suspension. And that's it for now.
Just like that. There might be a couple of questions. We're breaking for lunch. This is very exciting. So obviously thank you, Janine, lots of material. And so we are going to break for 30 minutes for lunch, come back and talk about those 504 plans, get into the nuts and bolts of working with your client, going to meetings, and then if we've got to litigate, ending the day with the due process. So the agenda is still on track. We're moving forward. If you have any questions that you didn't get to, of course, you could talk to us during lunch. You can not talk to us during lunch. It's totally your call. You can also write on those index cards if there's anything sort of lingering. You guys have been such an engaged group. Thank you for being here with us today. And lunch is right outside the door, so it's waiting for you. Thanks.
Thank you.